experience and most judges' experience, the removal to the circuit court was used as a sword rather than based upon an incredible reason to do so. So you could do it, but when you do it, then the judge is probably going to say, you remove this $12,000 case to the circuit court. I want you all to seriously think about using the ECA as your roadmap and your template on this case. Normally speaking, when the ECA process is invoked, it is by the plaintiff. And there's a form that will be part of the rules where the attorney for the plaintiff will have to go through the process, full disclosure, informed consent, those sorts of things. Then the plaintiff signs the form along with the plaintiff's attorney. Then the plaintiff can invoke. Now, some of the questions we received was, well, why can't the defendant opt out? And why do the plaintiffs get to choose? Well, they're the ones making the claim. If they don't use the ECA, then if it takes 2 years or 3 years to resolve the case, that's their own fault. If they do use the ECA, and let's say they believe their damages are $100,000, but it's going to take 3 years to get there, what's wrong with reducing your claim to the ECA limitation of $75,000 and get there in a year or less? So there's going to be cost benefit. So the ECA part is invoked by the plaintiff's attorney, full disclosure, signing the form. The election applies to pro se plaintiffs, representative plaintiffs, and one of the things that we thought was important also was that the parties, say the plaintiff doesn't invoke the ECA, files a lawsuit, good lawyers on the plaintiff side, good lawyers on the defense side, you take a couple depositions and you realize, we have some dispute here on liability, we have some dispute in damages, but we all know this isn't a $1 million case, it's not a $100,000 case. At that point in time, the lawyers can then stipulate jointly to using the ECA process. And then the rules are invoked, they can be used by both parties. I do a lot of defense work. I see the opportunity, even if a plaintiff doesn't invoke the ECA, to talk to the other lawyer and say, this would be a good deal. We could take a couple of depositions, have limited interrogatories. We both agree this case isn't going to get away from me, it's not going to get away from you. I know your client wants to have their day in court. And while we were going through this, one of the things that kept going through my head was Judge Kathleen Trandle. She's done a lot of work, a lot of research, been to a lot of different conferences to find out about what the perceptions are, what people's feelings are about litigation, those sorts of things. She says that we as lawyers got it all wrong. We as lawyers believe the outcome is important. She says all the studies show that the client believes what's important is that the process is what's important to them. Their ability to use the court system to right what they perceive to be wrong and ultimately use the court system in an effective, affordable manner and have a jury tell them whether they're right or they're wrong. And she says, we believe it's outcome-based. The clients believe it's process-based. And so this kind of tracks that, where you work with your client, and your client, if the client is truly concerned and really is more worried about the process than the outcome, this is a perfect vehicle and a perfect mechanism for them to do that. So you can do a joint motion There's also provision in there that the ECA claim can be terminated. Any questions at this point?
Bob, maybe this is a good time, you know, what I would like to maybe hear from everybody else, we're at the start, okay, what claims applies? I mean, I can tell you at least from my experience, what do I envision this? You kind of heard it before. I envision when that guy comes into me, or that gal comes into me and has a $20,000 breach of contract dispute. They didn't get it exactly in writing, they both have different ideas, and you know that they're not gonna settle, right? They don't want to settle. That's not what they want. If a jury or a judge tells them that the facts aren't in their favor, that's what they want to hear. That's one of the clear ones in my mind, those $20,000, $25,000 contract disputes. Another type of case that I see, and this is almost more of a trial tactic thing, but I hadn't really thought of these as being great for personal injury cases. But a couple things later on in the rule that I think will be good for personal injury cases. One, each side is limited to one expert, right? So you don't have to feel like you're going to get out-experted by someone else. My favorite part, though, 2-day trial, max. If you look in there, and 6 hours for each side to put on their case. All right? Whether you're a defense lawyer or a plaintiff's lawyer, you get sick of listening to your opponent, don't you? I mean, can we get on with it? Can we get things going here? And there's nothing more painful as a plaintiff's lawyer watching somebody cross-examine your whiplash client for 4.5 hours with their medical records. This limit, if you want to spend, if you're a defense lawyer and you want to spend 10 minutes picking the jury and make a 5-minute opening statement and then cross-examine my client for 5 hours and then give a 20-minute closed, you're free to do that. But I think we can move this stuff along and make it, well, like more fun. For one thing, more fun to be a trial lawyer again. And if people are forced to do it, they will. We had talked about this before. I've had some experiments with this kind of stuff before there was ever a rule. I had somebody call me on a little contract dispute that they had gotten sued over. And they was fighting over like $18,000, and Stan Whiting was the plaintiff's lawyer. And I knew they didn't have any money, but I wanted to get trials, I wanted trial experience, and Stan Whiting I knew would want a trial, and so I called Stanley and said, okay, I'm going to take this case and I'm going to do it for free if you promise me that you're not going to send me any discovery requests and we're not going to take any depositions. We're going to exchange any documents we have the week before trial, and then we're going to go have a trial. He said, yeah, I love that idea. Let's go do it. Now, it's a little scary, right? Not meeting the other party or having any opportunity to question them beforehand. But we did. We went. We had a trial. One of those great South Dakota trial stories. We agreed to have Mark Smith, the magistrate, try it, even though he didn't have jurisdiction under the statute, but we agreed that he did. And we got it all done in one day. It was in winter on a Friday. Judge Smith was reffing football that night. He took the jury's verdict in his football reffing gear underneath his robe. And both the clients were happy. Neither one got exactly what they wanted, but they got a trial and they got it done quickly. So I mean, if you're a young lawyer and you want to try it, this thing here is an opportunity for you to not have to rely on the grace of somebody like Stan Whiting or some other lawyer to do that. You have a rule that you can do it.
Absolutely. And you need to go back to your senior partners. I think Judge Day is probably the second oldest person in the room, besides me. Well, there's Bill. You need to go back to your partners and get out front on this process. It's Cliff's experience and mine, and the judges on the committee and the other veteran lawyers, is that what has happened is litigation is deposition. It's all about depositions. And you don't get to the courtroom. Well, there's a different persona, and you'll see this as you get more experience. There's a different persona that comes out of a lawyer in a deposition than in a jury trial. And if there isn't, that lawyer's going to piss the jury off all the time. And that's going to affect the outcome of the case. Don't fool yourself. Lawyers can lose cases. Mostly the facts win them, but lawyers can lose them. So what part of this was is that get that experience. And the experienced litigators out there right now are old. I don't want to be doing this in 5 or 6 years. This is really hard work. I wish this process would have been around 15 years ago. I'd rather have 10 $75,000 cases than one $750,000 case. And this process, I think, would have made me a better lawyer. I think it will make you better lawyers. You get 10 interrogatories. What does everybody do now? Paralegal. Remember that one case we had similar to this case? Well, why don't you print out the stock interrogatories? And that's 15 pages long. There's 60 interrogatories, not including subparts. It's a pain in the butt. Now, because of the limitation, you're going to have to be a better lawyer. You're going to have to think about what information do you need to defend your case or to prosecute your case. And you're going to fashion appropriate discovery to that end, not just shotgun stuff about everything. And that's part of our culture in South Dakota has been you throw everything out there, you then take a deposition. And how many times you've been in a deposition where 90% of the deposition is about the questions that were already asked in the interrogatories? We already got the answers. You know, it's all about wasting time, wasting clients' money, and I think that this will make us better lawyers. Our clients will think better of us, and we'll get great experience in the courtroom, because the experience in the courtroom is much different than the experience you get outside the courtroom. So I think those are the goals.
Does anybody else have any ideas of cases that you've seen or you're thinking about where this would be, I mean, oh yeah, I'm going to use this now, I've seen this. Anybody have any ideas? I'd love to hear them, so I can use them.
I think your classic somebody owes me money case. I get those all day long. This guy owes me $10,000, and I say, well, you're going to pay me $8,000 to get it, so it really doesn't make a lot of sense. It's essentially a breach of contract, but there's not always a contract involved, and there's really no remedy for them. Go to small claims on your own. You don't want to pay an attorney to get you $2,000. It's just not worth it.
And I think the best way when you go back and you talk to your partners, you talk to your colleagues in your law firm, is you walk through this and start thinking about the cases you have now that you wished you were using the ECA for. And if you have a good lawyer on the other side, you pick up the phone. Don't send an email. I am so sick and tired of email. I just tired. And Nate and Steve are sitting back there going, yeah, I know Bob. But pick up the phone and say, look, this new ECA rule came effective January 1, 2016. We really haven't done a whole lot on this, or we're at this point, can we stipulate to use it and do it? And one of the perceptions may be, well, the judges are going to be upset because there's going to be more jury trials. Judge Day is my former partner. We were together 25 years. He's been a circuit judge 2.5 years now. And you ask him, what's the most fun part of your job? Jury trial. So the judges aren't going to be upset if there's more jury trials, because they enjoy the jury trials. They get to see good lawyers perform. They get to see justice, civil justice, exercised and performed. And so don't worry about the judges. And I think most of them will welcome the break. Steve?
I think it'd be pretty handy for contested foreclosures, regardless of dollar amount. Because that's kind of a unique animal on its own. You don't have, typically you'd have maybe a dispute over what's the property worth, what's really owed, but that's, very similar to your breach of contract. And have you thought about why you're able to opt out of small claims but not be mandatorily put into this? Because it seems to me that would, I don't see why somebody should be able to opt out of a small claim and opt out of this. That doesn't make sense to me.
You can't opt out of this.
Okay, because you can.
Yeah, I mean, if you're a defendant and this is filed,
You're done.
that's it.
Good.
And that was the question. I mean, the question we got a lot was,
Right.
well, why can't the defendant opt out? Well, why can't the defendant opt out? Well, then you're not creating anything new.
Right.
Then you're relying on the Stan Whiting agreement between counsel. I mean, we've always been able to agree between us. So you needed something, and so why does the plaintiff get to do it? Well, the plaintiff is agreeing he only gets $75,000. That's the consideration.
Right.
And yes, Steph.
and maybe Judge Dave, you can speak to, this has always been my question about it, and I do have a case that I'm sitting waiting on this, just a soft tissue car accident. I think this will be the perfect vehicle for that type of case. But I was wondering what the commitment level from the circuit court bench is, because, I was just trying to think to myself, how many times even just routine hearings get bumped out of the way because of the obligation to handle criminal matters, and especially in courts where the courts really aren't in control of their own docket. And out in my part of the country, as Clint knows, our judge doesn't have she doesn't have a clerk. I just wonder how will that work? I see it's got to be tried within a year, except for good cause, and I assume that the good cause is if the judge moves it. But is there a commitment level by the circuit court judges that they really want this and they're going to make a priority? And have you thought or talked, is it a good idea to, when you do this, to give that call and say, hey, let's get on the phone now and get our date certain set at the beginning so the judge has it, not waiting for discovery to get done? What's the best way
Well,
to?
I can tell you,
So-
from the judges that were on the committee, which includes Judge Day, there was a consensus that this process would be a great process. We have that commitment. The next commitment becomes part of our commitment as individual lawyers. This is what I personally am going to do if I use the ECA. I file the ECA, I get my answer. The other counsel are going to get a hold of the judge. If the presiding judge, or the judge hasn't already put into place some mechanism that whenever an ECA is filed, there will be, within so many days, a scheduling conference. And once you have that scheduling conference, you look at the complaint, you can set, even though judges are busy and we as lawyers are busy, none of us probably have a trial set out a year from now. So you set that, because that becomes the cue. Once that jury trial is set, and it has to be done within a year, the jury date is then the benchmark date for the dates when you have to have your summary judgment filed, when your discovery has to be done, pretrial conference materials in, those sorts of things. So it's important, if you use it all. Get that trial date. And because that's what determines, it's all laid out here. The trial date is the trial date. All the other dates fall into play before that. Now, are there going to be people that are going to try to game the system? Absolutely. And that's going to be your job as a lawyer, and the judge's job to prevent the system from being gamed. But that was important to have members of the judiciary on this task force, is so that we could get some feedback. And the consensus it was unanimous. The ultimate rule we proposed to the Supreme Court was unanimous on the committee. So getting the commitment from the judges, that's part of our job. Them responding to that request for commitment, that's part of their job. And in your particular circuit, you may want to go to the presiding judge and say, Judge, it would be really nice if we had a set of pro forma procedures for ECA cases in terms of when we have to have the scheduling conference and those sorts of things. Because the judges, they're gonna want them on the calendar, but if you don't do anything for 9 months and you start cramming down, where you have 3 months left before you have a jury trial and you haven't done anything, why even have the rule? Is there another hand up? Becky?
How do you anticipate the good cause standard if they don't get the trial done in a year? Is it just, I know that there used to be a rule with the, if you were remanded from the Supreme Court, you had to retry your case within a year or it was dismissed. They abrogated that rule because of, I believe, the harsh outcomes that it represented. When you fail to prosecute, you know, it has to actually basically be stagnant for an entire year, which is not what you're going to have here. So somebody's working their case, they're trying their case, maybe it gets a little bit on the back burner, the year goes up. Are they done?
Yeah, I think somebody else asked me that question. My response is it's like pornography. You know it when you see it. There's no definition. And again, you know, we're putting a great amount of stock in the judges because the judges, a good cause analysis is an abuse of discretion. So it's completely within the judge's discretion. But if both you lawyers are going in to game the system by saying, yeah, we agree there's good cause, you can extend it out for another, a year, then we wasted our time at the ECA. Yes, ma'am.
Can you address the jury of one?
Sure.
I love the concept. I'm wondering how the circuit judges are going to like it. I mean, it's interesting that you give them jury instructions.
Right. And that's one of the things that I was most excited about. Yet, from the standpoint, it seems sort of illogical to be talking about your right to jury trial and then a jury of one. Go ahead.
Well, and I was just going to say, you hear people talking all the time about how court trials are so much better. They're cheaper, there's not as much preparation, there's not enough work, whatever. With all due respect to the judiciary, I think that's bunk. I mean, what always happens, if you're going to have a court trial, you usually have to write some type of pretrial brief, which you don't have to do in a jury trial. And you go and you present your evidence and you do it, and it's not as formal maybe with the objections depending on the judge and what they want. And then what always happens? The judge says, okay, submit me closing arguments in writing and propose findings of fact and conclusions of law, and then respond to the other sides. And so now you've done days and days more work than you would have just picking a jury. And what's the other part? Sometimes it's 4 or 5 months before you get a decision, rather than having. So going back to what Bob was talking about process, I don't know about what your experience has been, but my clients hate that process of not knowing. Another lawyer and I just agreed in April to try this out before the rule even came. And just said, Judge, we don't want to submit findings of fact and conclusions of law. We don't want to do any of that. It was a small town case, and we didn't want to do a jury trial because everybody knew both guys. Okay, so it would have taken us a day to pick a jury. So we said, we just want you to decide it, but here are the jury instructions. We've agreed to the jury instructions. You just tell us, what the ruling is, and our appeal rights, we put it on the record, our appeal rights will be just like it was if it was a jury trial. And the judge listened to the case, and at the end of it he said, no, I'm going to write. I'm not going to make a decision. I want to write an opinion. And that was in April, and we still don't have the opinion. So we're hoping that the judges will do it. Judge, you've heard the evidence. You took your note, taking your notes. If you want to take a half hour and think about it or whatever, but then come back in and tell us, just like a jury would.
Well, it was can I follow up? Sure. As a law clerk, I remember getting in one-sided jury instructions from one side, jury instructions from the other side, and putting a few together and throwing half of them out. And I'm wondering if that's what the judge will likely do on this as well.
But to me, it goes back, and I would, again, Judge Dave, if you'll take this back to the judiciary, we just want a fact finder to make a reasoned decision and decide for the clients. And it's different because judges usually have to explain their reasoning. You don't. just like a juror doesn't have to explain your reasoning. Got the jury instructions, that's the law. If there's objections to the jury instructions, you make your record, just like you would. If you think the judge got it wrong, you can appeal that, but the judge makes the decision, and then you go up to Supreme Court review it, and they said, are there facts in here to support the judge's decision? Just like a jury's. I think it could be great.
I think one of the, in my mind, the reason prior to now, it's a culture thing within the South Dakota and the bar and the judiciary. You have a court reporter, you have a record. You've taken all the evidence. It's down, it's there, it's recorded. And in my belief, findings of fact and conclusions of law, and all likely, in my belief, are redundant. And part of that is that some people believe that a clearly erroneous standard is much different than a deference standard to the decision of the jury, when really they're one and the same. Was there sufficient evidence to support the jury's verdict?